Good evening and welcome to Know Your Rights, the show where you hear directly from lawyers who break down the law and explain the rights of citizens on common legal challenges that confront Belizeans on a daily basis. I am your host, Khadija Usher. Tonight, we will be discussing your rights when it comes to child support, divorce, and spousal maintenance. We are pleased to have attorney Naima Barrow as our guest tonight. Good evening and welcome, Naima.
Good evening, Khadija. Thank you.
So we're speaking about three very major topics, and we'd like to get right into it. And we're basically starting when the relationship goes sour, you know? So in those instances, people would want to seek a divorce, but is it as simple as it seems on television? I mean, we see all these stars, they go and they get married, 10 days later you hear, oh shucks, they're divorced. Is it like that?
Oh, no. In Belize, normally a married couple can't get divorced until they have been married for 3 years. For you to get divorced earlier than that, you have to satisfy the court that there's a good reason for you wanting to come out of the marriage. So in a modern era where people take these commitments very lightly, or law has not been updated to move as swiftly as we do with other things in our society. So a couple has to be married for 3 years before they can get divorced, and they don't get divorced like you see them get divorced on TV where things, I just can't take living with this person anymore and I'm leaving.
Yeah.
Belize has what we call a fault jurisdiction, which is that there has to be a reason for you to get divorced. The law identifies 4 broad reasons. The main and first one is adultery, which everyone knows what adultery is. It's when somebody has been unfaithful in the marriage.
Yeah.
The second one is when one of the partners of that marriage has deserted the marriage and they had to have deserted for 3 years. The other one is cruelty. Now, cruelty is not just limited to physical cruelty. It includes mental cruelty, and I think it's the broadest ground, the one that a lot of things can fall under. And then the last one is if your spouse is of unsound mind, but has to be of unsound mind for 5 years.
5 years? 5 years.
So it's not something that you should take lightly. It's not something that our law takes lightly, but it does happen, and that's the reality of the society and situation in which we live. So that is it.
So we're talking from a position where, let's say we've filled one of these 4 criteria for under the law, you can get the divorce.
Right.
What is the procedure to getting the divorce?
You petition, there's an application that you make to the Supreme Court, and that application must cite and contain the grounds of your divorce. So after you have established one of those grounds, you make an application to the Supreme Court. After you make that application, you have to serve that petition on the spouse that you're seeking the divorce from. That spouse, depending on whether or not they live in Belize City or outside of Belize City, has 8 or 15 days to file what you call an acknowledgement of having received that petition, and within 14 days of filing that acknowledgement, you then file your answer. That is in the event that you intend to contest the divorce. So your spouse is accusing you of something and you accept that that is what has happened. There's no need for you to contest or answer what has been said. If there is something that has been said that is not true, then you have a certain period of time within which you must file your answer. We try to act like it doesn't matter because in other countries it doesn't, but the grounds of your divorce oftentimes plays a significant role in the maintenance that you have to pay in terms of whether or not you're at fault. So if the marriage broke down because of you, then the court will look at you as the person who will be responsible for ensuring that the spouse who was the victim of some unfaithful or cruel behavior is properly taken care of. So it makes a difference a lot of times who is found guilty of having caused the marriage to break down.
And you mentioned maintenance. This also incorporates any form of settlement that must be made?
Yes, the law contemplates 2 forms of maintenance. There is what we see in TV, alimony.
Yeah.
Alimony in Belize contemplates a gross sum, a lump sum payment, and there's maintenance that you hear people say all the time. Maintenance is usually weekly or monthly sums, so they're smaller sums. And the truth is that you can get both. The sad reality is that our law that provides for alimony is so old, 1983, I believe.
Okay.
So what it contemplates is a wife receiving alimony.
It does not contemplate for a man.
It does not contemplate a man receiving alimony.
Okay.
And it's just because of how old the act is when it was made into law.
Yeah.
It's a couple of years after independence, and at that time, women were expected to be dependent on the men, and so it was assumed that those are the people who would need alimony. The happy situation is that Families and Children's Act also makes provision for providing support to families, and it's a newer act, and therefore it contemplates a husband being entitled to get some support from the wife in terms of maintaining. The thing is that maintenance is normally limited to the child, but there is provision in the Families and Children Act, which I think was passed in '95, for this, if the husband is the spouse that has the children, and that does happen, if the husband is the spouse that has the children, then the wife would have to contribute to that husband's maintenance of the children.
And just before we get more in depth with the children, which we will,
Sure.
During the marriage, you would have, your husband and yourself would have accumulated a certain amount of wealth, a certain amount of property,
Right.
a certain amount of items. How is it determined in a settlement who get what?
It depends. It depends on the structure of the household. If both spouses are working, and in this day and age, it's quite possible that both of them are making about the same amount of money, it's kind of easy. It's a 50-50 split if what you're bringing to the table is as much as your spouse. But it's not. It's hardly ever that clean and clear cut, because there are instances where either spouse, and we used to say the wife, but husbands as well,
Yes.
stay home and take care of their children,
Yes.
and that contributes to the welfare of the family. The court factors in that kind of non-financial contribution. There are things that you do at home that improves your family, providing a stable environment, raising your children, contributing to the management of the things brought into the home.
Correct.
Those things factor in.
Yeah.
If your spouse is at home taking care of the family, then you're free mentally to go out and make the money that you need to make to provide for the family, and that person's contribution has to be factored in, even though it's not a financial contribution. In addition to that, there's also, the court does consider what will happen to the parties after they have gone their separate ways, which is, will the mother or the father be able to maintain the same lifestyle as they had during the marriage? And the aim is to keep the children who the court seeks to protect, keep them in as similar a position as they were before the marriage.
Focuses on keeping the kids stable.
Keep it what's in the best interest of the child.
Interest.
You will hear that in family court, you will hear that in Supreme Court. It's what is in the best interest of the child. So that is generally the primary consideration, and it needs to be, because the parents have voices, the children hardly ever do. So somebody has to think about them, the courts think about them.
The court does. And so coming from that perspective, how do the court determine who receives custody of the children?
Best interest of the child.
Best interest of the child.
And the assumptions that have historically been made, which is the mom is the best caregiver, it's not true.
Yes.
It's not true. Too often, fathers are overlooked for the overwhelming contribution they make to their child's stability, being able to provide a stable environment, being able to provide the resources needed to that child, and as well the emotional support that the child needs. So depending on the child that you have, they might have formed a closer bond with the father as opposed to the mother.
Okay.
Those things are factored in. So it's not automatically that the child will go to the mother. No,
with the father.
it's not.
So the court does its due diligence in making a
Yes.
proper evaluation
Yes.
of the situation, best interest of the child.
It's easier for parties in the family court, because the family court relies a lot on reports that their social department does. So they will do an inquiry, and as a result of that inquiry, there will be a non-partisan person providing a report which will affect the court's decision. In the Supreme Court, usually you have to give your own evidence. You will have to provide the court with why it is you ought to, or why the other parent ought not to be the parent with custody of the child. So the family court contemplates more of their support and assistance in getting the families through that process, while in the Supreme Court, you will need to put forward your own evidence as to what is taking place or what is not taking place.
And we'll get much deeper into the legal aspects of custody of the child as well as child maintenance as soon as we come back. We just need to take a short commercial break.
Sure.
We'll be right back. Good evening and welcome back to Know Your Rights. I am your host, Khadija Usher, and we're here with attorney Naima Barrow discussing divorce, child maintenance, and child support. We had a very good introduction of divorce as well as the custody of the children from the marriage. But if a parent wants to file for custody, what is the procedure that they would go through?
They can do it both at family court and at Supreme Court, and the procedure is a little bit different. At family court, I think it's easier because there's someone known as an intake officer that you would go to, and that person will help you draw up your application. They will help you cite the relevant parts of the law and put in what needs to be put into your application to go before the family court. You can do the same thing at Supreme Court. There's just not anyone there to help you. Okay. So that is where you would turn to the services of a lawyer, private legal aid, because there are certain things that must be included in that application, and most lay people don't know it. It's a matter of choice, it's a matter of preference. Some people prefer to have control over their own proceedings and not have someone that they don't know do the paperwork for them. Those who so prefer go to Supreme Court. Those who can do it, their assistants, tend to go to family court. Okay.
We'd like to get a little bit into the child support aspect.
Okay.
When the determination is made of who the child goes with, mother or father, how preferably does the court determine how much child support is provided?
The means of both parents are looked at. The means of the parent that has the child and the means of the parent that doesn't have the child. And those things would have gone into the consideration of custody as well. So if the child, for non-financial reasons, end up with the parent who is less financially stable, the more financially stable parent will be required to contribute as much as that parent can for the child. There is this misnomer going around that you get $50 a week if you're lucky, and relax yourself. Yeah. That's not how it goes. Okay. It depends on the means of the parent, and sometimes a parent can't afford $50 a week. That's the absolute reality of the situation. Okay. And sometimes that they can. The hope is, with everybody dealing with the situation, that the parent will remember the child and not seek to be malicious to the parent that has the child. So what a parent ought properly to consider is what their child needs and what they can afford to give them, and that is what the court will consider as well. So those are the considerations.
But in certain instances, would it be fair to say that there is an imbalance between the means that the parent can afford and the needs of the child? Because, for instance, you're explaining that it is what that parent can meet. Mm-hmm. But what if there is an excess for the child's need? Where does that come from? Would it then just have to lie on the parent who has custody?
When you say excess, what do you mean?
For instance, the $50 a week. Mm-hmm. You go to Publix and you try to get Pampers, you try to get milk, you try and start enroll up preschool. Mm-hmm. $50 a week cannot meet all those needs. Mm-hmm. Additionally, especially if, as you said, the parent who received custody is not the one who is financially able. Mm-hmm. Where does that excess come from?
Well, where it comes from all the time, whether or not you're separated, you have to find the means for your child. That's your duty, that's your obligation as a parent. So if you have a a school-age child, you will need to find the money for your child to go to school, and that is whether or not you're separated or you're living together. And those considerations and those obligations don't change with divorce. The hope is, like I said, that the parents will make that effort. The sad reality is that oftentimes the parent who does not have the child sometimes loses sight of that child in the separation, in the divorce, and say, you know what, you want the child, you deal with it. That child remains both of your children, regardless of what happens. Now, what happens too often is that the spouse that has the child doesn't know how to put together the information they need to put together to prove to the court that the other spouse has enough to give more, and that is really an obligation on the party seeking more. You have to be able to demonstrate that there is more to have. There is more for you to get. If there's no more for you to get, then there's no more for you to get, and you will have to do what you have to do, as any parent would. But it is the hope, it is desirable that the parents will, like I said, not lose sight of their children and do what needs to be done. That's what's supposed to take place.
And you're speaking about the demonstration that the other parent actually has the means to give more. Is there a procedure or that this parent can basically go back and say, listen, my ex has certain engage in certain new business ventures. He has a new stream of income. He's making so much more. I need more money. I can justify my needs to you. I could justify his means to you.
Absolutely, because the obligation to care for your child is ongoing, and the dynamics of a situation changes. You might get more money, and the husband or wife might apply and say, you know what, the spouse with custody doesn't need as much from me as they used to, because they're doing better. Or the spouse who does not have custody, like you say, might get a better job, get a promotion. The child is entitled to benefit from your improvement in life as well. And if any parent has the means to do better, the truth is that they ought to. So the sad reality is that you may have to go back, but that parent should be able to say, you know what, I made that contribution, or I was ordered to do that when those were my means. Realistically, I can give more and I ought to give more, because you're not giving it to your spouse, you're giving it to your child, and that's what's supposed to take place.
And what mediums are in place to ensure that the maintenance is being paid? Because, I mean, we see it on TV, we see it right in our neighborhoods, like the coin term now is the baby mama drama. The ma have to run after the pa, or have to run after get leave money for this, get leave money for that. What legally is there to empower whoever is the receiving party that they will be paid this amount of money? If an order is made for a parent to pay a certain amount as maintenance and they fail to comply with that order, they're in contempt. They're in contempt of a court order, and the remedies available to any beneficiary or any recipient of an order is the same. You apply to the court to hold them in contempt. Now, what you have to understand is that the failure to pay is not always willful. So what you will have to demonstrate is that that person purposely and willfully missed or failed to comply with the order. So it's not simply because he didn't pay his $50, you can go to court and the court will do him something. You need to show that he had the means to pay the money that is due and did not pay it. People get fired, people lose their jobs, people get sick. If those things happen and a person fails to comply with a court order, the court can't properly do anything to that person because they had not the means. But if they have the means, you will get that person back before the court, demonstrate that they had the ability to pay, and the court will deal with them. And I have seen people imprisoned. I have seen people imprisoned over it. So it's not something that the court takes lightly. The welfare of that child will not be overlooked. If the court is convinced that you have the means to do it and you're being willfully disobedient, the court will deal with you properly because of that child. That is what happens. We've spoken on child maintenance and child custody in terms of the divorce. Mm-hmm. Do similar circumstances apply for common law relationships?
Yes. Let us be very, very clear now, because I understand that people think that once you live together for 5 years or a certain amount of years, you're in a common law union. Our society does not allow bigamy. So for you to be in a common law union, which is akin to a marriage, both parties need to be unmarried. You can't live with a married man for 5 years and think that you will get common law status, because you can't. If he remains married, he remains married, and he's not available to be in a common law union. Vice versa, a married woman remaining in a marriage cannot be in a common law union with anybody. So having established that the two other people were single before they moved in and they've lived together for 5 years,
Okay.
the law looks at it now since 2001 very much like they did historically a marriage. So you're entitled to the separation of property, you're entitled to all that is entitled, that the law gives between a legally
spouse.
married couple.
Yes.
A common law union does that. And the happy thing for children is that whether or not that child was born in or out of a common law union or a marriage, their obligations, their entitlements are the same. But as it relates to people living together for 5 years, the law now recognizes that it's akin to a marriage once the persons were single before, and they treat with them in the same fashion.
And fit the 5-year criteria.
5 years.
We will return very shortly, and when we return from the break, we will ask Naima some of the questions you posted on your Facebook page. We'll be right back. Hi and welcome back. We invite you to join in the conversation by posting your comments or questions on our Facebook page or by emailing us at info@colorblind.bz. So we thank you for your questions and comments. We have selected 3 of your questions to ask our guest attorney. First up, Andre wants to know, why is it that some men only have to pay $25 per month to support their child? Is that a minimum the magistrate can demand? Can the lowest possible amount be bumped up to $150 per month?
There's no minimum or maximum. It comes down to what a parent can afford. Now, you can't have a child and say you can't afford to give anything because you had a child. So when you had a child, you knew that there were certain things that you would have to sacrifice of yourself for your child if you did not have enough to go around. But there's no legally mandated minimum. There's no set maximum either. It really depends on what that parent is able to give or what the other parent can demonstrate that the parent is able to give for those parents who are unwilling to give. So there's no minimum, there's no maximum.
I guess the question just really comes because a lot of the feedback we are receiving is something like the amount many of the parents are willing to give are very low, and especially from us who are living in the society, and we know the cost of these goods to maintain a child. So
it's not supposed to be that way. That is the truth, and a parent ought to sacrifice and do what needs to be done. So you can't sit down and say, oh, the child lives with the mother or they lives with the father, so I'm not doing anything. You have an obligation to contribute to that child's welfare, regardless of whether or not you have custody of the child. So you must do what you can, and the court will not allow you to say, oh, I've been unemployed for 5 years. How are you eating? Somebody's helping you to pay your bills. You need to take that assistance and stretch it to meet your child, because that's the truth. As adults, we need to work to live. So you need to work to have your child live as well.
And we didn't mention, but can a settlement be agreed upon outside of the courts? I mean, as parent to parent, you keep stressing, think best interest of child, think best. If me and my husband can come to agreement that our child needs such and such to survive and have a very decent life, can we make that arrangement?
Absolutely, and it's preferred. If the parties can reach that level of maturity, clarity, and focus, then you can make an agreement, and what is advisable is that agreement, once made, try and get it supported by a court order so that the person can't on quarrel day deviate from that agreement and say, you know what, I'm not messing with this today.
Okay.
So you can agree between you what you think is reasonable, and if that is done, go to court, any court, and ask them to please make the order in terms of the agreement reached.
Okay. Can we go to our second question? Our second question is from Mati. Mati is asking, after 9 years in a common law relationship where the man is not maintaining the child nor the wife, what are the benefits that she and the child are entitled to? 9 years.
Without knowing the details, you're entitled to what any anybody in a marriage would be entitled to. You're entitled, the children are entitled to what all children are entitled to, which is reasonable support from the father or spouse of that union, the father of those children. You can apply to court for support. And most people say, oh, I don't want to go to court because I don't want the relationship to go bad. If you've been apart for 9 years and they're not supporting you, your relationship has gone bad. It's gone bad for you and it's gone bad for the children. Go to court and ask them to please bring him to court and let him demonstrate his means to provide for the children. After 9 years, you're supposed to have a good idea as to what his means are as well. So you would have an idea of what it is that he historically gave you, what he historically gave the children. That's a good starting place, as long as the circumstances haven't changed.
I think also we need to emphasize the points you made earlier, that a lot of people nowadays are really throwing out common law casually. And legally there is a very detailed or a very clear criteria for common law.
You must be single, as in unmarried, and you must have been living together for 5 years. So married people cannot be in a common law union. You just absolutely can't. So the fact that he or she calls you my common law does not make you a common law. Signing a paper in front of a judge, because in front of a justice of the peace, does not make it a common law union. It has to be, as a matter of fact, that two single people have been living together for 5 years.
And our final question comes from Keisha. Keisha asks, how can a magistrate take out a mother and her child out of the home without the mother working, while the father is not made to pay arrears for the child? It's an emotional question. It's very deep.
It seems unbelievable.
Yeah.
The circumstances, the facts given seem unbelievable, but there are a lot of things that go into making that determination. On the bare facts that she's given without anything more, it may have been that a bad decision was made. And we must remember that the law is administered by people, and people make mistakes. And there are procedures for dealing with those mistakes. So if you've gone to a court and they've made something of a bad decision, you have the right to go to the court above. Family court, you can appeal to Supreme Court. Supreme Court, you can appeal to Court of Appeal, and it goes up depending on how unfair those circumstances are. So that seems to be what might need to be done in those circumstances. Putting out an unemployed mother and her child sounds very, very harsh and very unusual.
Okay. There must be some additional technicalities tied to it.
Oh, there has to be other factors that aren't being said, and if they're not, then that person needs to go above whosoever made that decision, because something is wrong with that decision in the absence of anything more.
What are the final points or the main points that you would really like to emphasize to the family or families who are finding themselves approaching situations where there may be a divorce or they're going through a custody battle, a maintenance battle?
It's hard depending on why it is you're getting a divorce. It's not easy, but what you must remember is what it is that brought you together and what it is that created the children of that union. So as couples separating, at one point in time you loved each other to the point that you got married, you lived together for 5 years. There was some love there. Do not allow hurt feelings and malice to dictate how you will live the rest of your life. Do not allow hurt feelings and malice to deprive your child of what is due to them. So if everybody could agree, it would be ideal. The truth is that you can't. But try your best to take away the hurt feelings out of those decisions that you make and think about the other person, think about yourself, and think about your child in making those decisions. It would mean less work for us lawyers, but it's what is supposed to take place, that we are to be mindful of the family as a unit that contributes to the building of our society. That is what I would say.
Thank you, Naima.
You're welcome, Khadija.
We have come to the end of our show for tonight. Thank you, Naima, for joining us and providing so much information on tonight's topic. I am sure the viewers learned a lot. Know Your Rights will be back next Monday at 8 p.m. with attorney Magali Perdomo, who will discuss your rights pertaining to labor laws. Thank you for watching, and tune in next Monday for another episode of Know Your Rights. Good night.